Hello, everyone. Thanks for joining us today for a part 2 of the Q&A from our May 12th webinar on surprise medical bills, Senate Bill 1264, and the independent dispute resolution process. I'm Ben Gonzalez with TDI's Public Affairs Division. So this is not a repeat of that webinar, but a continuation of the Q&A portion in order to answer more of your questions. So no additional CE credit for today's session. So joining us again to take your questions is Cindy Wright, the Director of TDI's Consumer Protection Office. Hello, Cindy.
Hey, Ben.
So before we get started with the general Q&As, we have a couple of slides to go over that's going to help set the scene and maybe answer some of the questions we already have about program statistics so far. Cindy?
Yeah, thanks a lot. Okay, I'm just going to share my screen with you guys here real quick. We did want to just give a little bit of, refresh before we kind of really get going. And just some background on Senate Bill 1264. So passed in the 2019 legislative session. It applies to fully insured health plans, ERS and TRS. So Employee Retirement System of Texas and Teachers Retirement System of Texas. It applies to medical bills for services or supplies received after January 1st of 2020, when there's emergency care involved or out-of-network services that were received at an in-network facility, so the patient may not have had a choice, and then also lab or imaging services in connection with their in-network care. So just really quick breezing through the timelines. So the law established 2 different processes, and I definitely wanted to kind of go over this just really quick because we had a number of questions in the first webinar that kind of made it seem as though some folks might think that it's one process. So arbitration is specifically for professional type services. Mediation is for facility type claims. And so there are 2 different timelines associated with both of those processes. The arbitration timeline is really pretty short. So providers can submit requests starting 20 days after the first claim payment. The first 30 days of that request are an informal settlement period. The provider and the health plan should be having a negotiation, a conversation during that period of time. Hopefully the request settles. If it settles, then that information is just entered into our portal, and the matter is settled once the insurance company reports back on any additional payment. If it doesn't settle, then on day 31, an assignment will automatically be made of an arbitrator. And then from day 31 to 51 is the arbitration period. Day 51, provided that no one has requested an extension, then day 51, everything is done and done. The mediation timeline is really very different. And this timeline is associated with the previous or the laws that existed before 2019. So still a request can be made anytime, 20 days after the date of first payment, but there's no kind of end date associated with that. Still a 30-day informal settlement period. On day 31, if agreement hasn't been reached, then a mediator will be assigned to the request. And then up until day 180, the parties are able to hold a mediation conference. And then the mediator's report is due within 45 days after that. So that just sets the stage a little bit. Again, the 2 different processes. And, all of you were with us in the first webinar presentation, and I don't know if you would recall any of the numbers that we showed at that point, but these are, different still. It's been about 2 months or so since we, or a month since we did the last presentation. So we've gotten so far quite a few arbitration requests submitted, an awful lot of those settled during the initial 30-day period. And then we have over 58,000 that have been decided by an arbitrator. For mediation, you can see the numbers a lot different, right? So we get far fewer mediation requests. But if you can compare the numbers and do a little quick math there, the settlement rate seems to be a little bit higher during that initial 30-day period. Because the timeline is so short, you can see how it kind of funnels down pretty quickly, right? So, 1433 have concluded mediation, and that's simply because, those kinds of requests can stay open for up to the 180 days. And then you'll see it might look a little confusing, the last two bullets there. 1,400 have concluded mediation. Mediation conferences don't have to result in a settlement agreement. But of the 1,433, 462 have settled as a result of that conference. And then we wanted to also share some program statistics. So it's just pretty large numbers, as you can see here. The total amount of settlements, over $311 million. It's a pretty big number. So we definitely wanted to share that update with you too. Just pulled those out as of this morning. Kind of a recap of some of the arbitration decisions that we have. So arbitrators do they do a lot of things, of course, but two different things that we just really wanted to point out here. The first thing is they're deciding upon what's the reasonable amount for that healthcare service. And the second part of that is whose final offer, the health plans or the providers, is closer to that reasonable amount. And so given that information, then we see health plans are winning about 34% of the time. That number has been pretty consistent since the beginning of the program. And then the flip of that is providers are winning about 66% of the time. And then you can see the averages there as well. Requests that concluded mediation, about 32% of those requests are settled at the mediation conference or as a result of the mediation conference. And we've got some averages for you there. And that's all I have. So I'll stop sharing.
All right, we'll start getting some questions then. So joining Cindy to help answer your questions today are Randall Evans. He's our Deputy Commissioner of Customer Operations.
Good afternoon, everyone. Thanks, Ben.
Leah Gillum, she's Deputy Commissioner of Fraud and Enforcement.
Thanks for having us.
And Robert Simons, Assistant Director of the Office of Policy Development Council in TDI's General Counsel Division. Hello.
Good afternoon.
So before we get going, just like for all of our previous sessions, any questions about specific companies or entities, we'll need to answer those offline. So of course you can email us those, send those kind of questions to idr@tdi.texas.gov. And I'll give you that email again at the end of the program. All right, let's continue with part 2 of our Q&A on surprise bills and the IDR process. So Cindy, here's one about claims and amounts. It says, during the original presentation, you mentioned claim aggregation can be of up to $5,000, but an individual claim is unlimited. Is that correct?
It is correct. So when it comes to arbitrations, requests can be aggregated up to $5,000. So it could be one claim. I mean, it could be 2 claims. It could be 50. But $5,000 is the limit on that, and they can be aggregated. On the mediation or with mediations, there's not a limit on the amount of aggregation. The only stipulation really is that the parties agree that they can aggregate claims.
Okay, sounds good. Here's another question. Have you all determined any relationship between the arbitrator's fees and the number of assignments that arbitrator gets?
Yeah, sure. I think I'll pitch this one over to Randall Evans.
Thanks, Cindy. Actually, in fact, no, we have not found a correlation to the amount of fees that are charged associated with the number of assignments. We have a regular rotation. That rotation includes five facilitators being selected, and then each party can eliminate down to the last one. But they determine who they select, and that may not be a decision. The fees may not be the determining factor as to who's selected.
Right.
Okay.
So, and I actually add on to that a little bit. So the list of arbitrators and mediators is maintained on our public site. The CVs or resumes for each of those individuals is available for viewing, and as well as their fees. So we provide as much information as we can. And, 2+ years into the program, I'm sure there are some, the work product is sort of known, I guess. Parties could be familiar with an arbitrator, for example, or a mediator, and may prefer them over another. And like Randall said, for sure, we haven't done any analysis, or I don't think we'd be able to figure out whether or not there's a direct correlation between the fees charged and the assignments.
Okay, moving on to the next one. Is post-stabilization care covered under the IDR process?
So I think, the best way to describe it is really if the patient doesn't have a choice in the provider that's chosen. So that's why the law is specific to emergency care. And then if there's an in-network service at an in-network facility and you have out-of-network providers that are providing services alongside that, then those are the situations where it would be eligible. There might be policy terms that dictate when someone has to, have an authorization to continue care in a specific facility. So I don't know if that's the, super firm answer to that. I don't know, Bob, if you have anything that you would add.
Yeah, I guess a little
Mhm.
bit. So the insurance code 1467, it has a definition of an emergency care, and it uses the definition that's in chapter 1301, which is the PPO chapter. And I think it's 1301 section 1301-155. And it is a little narrower than I think the No Surprises Act in terms of how emergency care is defined. So it's too fact specific, I think, to really get into whether or not a specific service is going to be post-stabilization care or not. I think just broadly, it's a little bit more narrow than the Federal No Surprises Act. And so that's one of the kind of distinctions between the two.
Okay. We have a couple of questions about fair health and how that's being used. First one, how do mediators determine what's considered usual and customary for allowed amounts? Is that info only from fair health for arbitrations?
Yeah, okay. So the question started with mediations, and I want to draw a little bit of a distinction there because the arbitrators that are, are working with this program have access to fair health data. Fair health is the benchmarking database that TDI selected. But that's specifically because when they're making their decision, they're evaluating 10 factors that are listed in statute. And two of those, or actually, I guess you could say 3, are directly related to that fair health benchmarking data. Mediation is different. That, the mediation conference doesn't require that kind of information. It just requires, that the mediator and the two parties, are getting together and discussing the claim. So if they wanted to use that information in their discussions, they could, but the arbitrators that work with the program are the ones that specifically have access to that benchmarking data.
Okay, so this might, I'm not sure if this is associated or not, but it's a, so we could say for arbitrators, if my organization doesn't use the fair health, how can we answer those questions?
So I'm not sure what organization that might be. Fair Health provides a lot of data to the general public. And my suggestion would probably be to reach out directly to Fair Health and see, what kind of data access they might be able to provide. Yeah, I'm just afraid we don't have a whole lot of information about that.
Yeah, and I guess let me follow on. So, so the statute specifically mentioned Dutch benchmarking organization that is selected by the commissioner. So the commissioner selected Fair Health. So that is a decision that only the commissioner gets to make, and that decision has been made. Then in 1467-083, which is the 10 factors that an arbitrator should consider, I think 2 of those factors directly come, and they specifically mention the benchmarking organization in 1467-006. So that is Fair Health. So an arbitrator should not be using benchmarking data related to that factor 6 and 7 unless it is coming from Fair Health. That is the only benchmarking database that is appropriate for those 2 factors of the 10 factors.
Okay, this one is very much associated. This is another question. Numerous plans have referred to amounts paid by Medicare, even though the 10 factors don't mention Medicare. Are we supposed to give any kind of significance to Medicare?
Gotcha. Thanks, Bob. I could see you starting to answer that one.
No, you can go. You can start. I'll jump in.
Okay. Okay. Yeah. Well, so I guess the way I would answer that is to say, when the arbitrator's collecting information from the parties can supply whatever information they're going to supply, but the arbitrator is going to be considering the 10 factors. That's not one of the 10 factors.
I think that's exactly right. You probably said it better than I would have, and probably shorter. But yes, there are the 10 factors that are established by statute. The arbitrator should not go outside of those 10 factors. And I will, I think we can all acknowledge some of those factors are kind of fuzzy and kind of, narrative driven, right? The specific individual enrollee characteristics, that's, what does that entail? I think there's some subjective judgment involved on behalf of the arbitrator, but, and none of those 10 factors is Medicare rates specifically identified. I know that, again, some of those other kind of rates are now part of the federal no surprises IDR process, but that is not the Texas process. And so unless or until the state legislature decides to amend chapter 1467, that's not one of the 10 factors.
All right, sounds good. Next question. To avoid surprise bills, is there any way to opt out of the out-of-network services for consumers?
Okay. Yeah, it sounds like that comes from a consumer. In a practical sense, I think if you're just out and about and you have some kind of emergency event, I don't know that as any of us as consumers would have the option to opt out of care if it was needed, on an emergent kind of basis. But certainly a consumer can, look at who's available in their network for planned kinds of services, a primary care physician, for example, and do their very best to, if you have a procedure that you need to arrange, making sure that you're using an in-network facility for that, and that the referring physician is referring you to, an in-network surgeon, for example. You should be able to check all of that with your health plan. This bill was intended to help consumers in the situation where they don't have a choice. So those emergencies and where, you've planned something, but maybe that facility has an arrangement with, a radiology group, for example, for certain things, and they don't happen to be in your network. So I think that pretty much covers that one. I don't know if anyone has anything to add to that.
All right, we'll just move on from there then. Next question is, why are we not able to download the case details for open cases into a spreadsheet like we do for the case headers?
Okay, well, this sounds like it's probably coming from one of our portal users. I would say, not to put you off or anything like that, but please reach out to the IDR team because they can provide, all sorts of, technical expertise, and they're glad to help you get what you need.
Okay, IDR@tdi.texas.gov, and we'll get back to you if we can. Next question. If a payer has denied a CPT and put it to patient responsibility on the EOB, is that code eligible for the IDR? I'm just saying letters at this point. Process, since the EOB states that it's now the patient's responsibility, how do we determine what's the patient's responsibility?
Yeah, okay. Well, it sounds like kind of two different questions, but if there's a denied CPT code, the denied services aren't eligible for IDR. So my suggestion on that would be, go through your ordinary appeal process, external review, if that's what's needed.
Okay. Next question here. Does Senate Bill 1264 cover CRNAs when the CRNA is out of network at an in-network facility?
Yes, that sounds like, without having the other information, about it being patient choice and et cetera, the provider type would be able to, submit a request through.
Yeah, the statute and the rules define out-of-network provider, and the definition, it lists diagnostic imaging provider and emergency providers, but it also mentions facility-based provider. And so if a CNRA is a facility-based provider, then it would apply.
Cindy, I don't know if we can do this one on the fly, but this person asks, I noticed on the mediation side that there's a higher percentage of accepted. Can you break that down by year? Or is that one we'll have to get back to?
I think we've got some folks on the IDR team that are listening in, and they'd probably be, I don't have access to it just on the spot, but
Right.
you might be able to text that to me. So if we can just circle back to that question in a little bit, we might be able to get an answer. But yes, we can definitely break it down.
Yeah, and if we don't get to it today, go ahead and send us an email and we'll follow up with you.
Absolutely.
Next question, how are we supposed to arbitrate claims that are successfully appealed and processed with a claim extension? Is that technically a brand new claim? IDR said yes when we asked back in March of last year, but now we're having issues with this again. Situational.
So, yeah, I'm not really, I need a little bit more detail on the question. We'd be glad to research that for you. So the law reads that the date, I guess the timeline triggers off of the date of first claim payment. And the really part of the rationale behind a kind of a 20-day hold, so to speak, after the date of that first claim payment is to try to resolve things like, appeals that may be pending or extensions that may be pending. But yeah, we need a little bit more detail to answer it more specifically. But we'd be glad to get back in touch.
Okay, sounds good. Next question, how will the arbitration decisions affect, if at all, the settlement amounts from providers and health plans? It's kind of a general.
It's kind of a general one. I mean, over time you would, I guess just logically maybe think that over time, a process like this is designed to help sort of begin to narrow the gap in the middle, right? So you would sort of expect that health plans would be potentially processing at a higher rate, and then billed amounts might kind of come down. So you would expect to see some narrowing in there along the way.
Yeah, I agree with everything Cindy just said, and we hope over time that kind of as both providers and health plans have more information about what kind of final outcomes come out of arbitration, that drives them to have a productive informal settlement conference period, so that they each know what are just past experience from having gone through this process, what are reasonable amounts to pay and accept, and hopefully more and more over time kind of settle out into that informal settlement conference. So that's kind of a subjective, fuzzy reality, but I think that's kind of the hope and how the process is claimed. And I wonder if there's also in the Federal No Surprises Act, there is a process by which once there's been an arbitration that kind of establishes the price for the next period of time. And that is not something that we have in Insurance Code 1467. That's kind of the newer innovation that the No Surprises Act has. So there may be some confusion in that.
Yeah, we definitely have the federal process and the state process. Here's a related question along those lines. Would claims that do not reach a resolution going through the TDI process then be eligible for the federal IDR process?
Well, I'll start with that one. I bet you Bob I'll have way more stuff to add to that. But yeah, so the federal law allowed states that already had a process like this one in place to just carry on with it. So if there's this, my understanding is if there's a state process in place, they wouldn't then go on to the federal process.
Yeah, I think that's accurate. Yeah.
You concur?
If I can, Ben, if I can make that plainer, in case anyone missed that, you had to choose. Either you're going the federal route or you're going the state route. You can't have both.
Okay, sounds good, sir. Next question. What is the process for becoming an arbitrator?
Actually, I'll reach back out to Randall to answer that one.
Occasionally, we will open up our list to add more arbitrators when we don't necessarily have the volume of facilitators available. Right now, we're very well fully stocked. We're not looking to open up that list anytime soon. I think we've done that maybe twice, Cindy, since inception. Two, maybe three times. But at this time, since we have such a in-depth list of facilitators, right now at this time, we're not looking to add any more, either mediators or arbitrators at this time.
Okay. Another arbitrator-related question. Is there data available that shows that arbitrators are siding more with providers? And are we able to view the criteria that's used outside of the fair health factors?
Okay.
Two-parter.
Yeah, well, data as to why, that's gonna really, all of that information is gonna reside with the provider that submitted the request, the health plan, and the arbitrator. TDI doesn't have access to, the decisions that the arbitrator makes other than through their reporting in the portal. So that's really just outcome. That's not rationale. Position statements that each side might provide to the arbitrator, those are not provided to TDI either. So that kind of data we wouldn't have. And then you said, are we able to
view criteria that are used outside of the fair health factors?
Okay, I'm not quite sure. I'm not really quite sure how to answer that part of it, but I guess the quick answer is we don't have access to certain documents, really just the reporting feature through the portal.
Okay. Regarding the portal, are there any plans to allow comments to be added for unusual circumstances so that we can add in additional information? This person says, I've had 2 instances where the resolution deadline was missed because one party just didn't answer. So is there any way to address that?
Yeah, actually there is. So it sounds like this is, from one of the facilitators that that works with the program. And I'll reach out to Leah for a little bit of follow up on this one. But when there's a couple of different things that we look at in terms of, potentially being bad faith participation, and not responding is one of them. Not participating in the informal teleconference is another. And then, not paying the facilitator upon assignment is another. And so we work really closely with other programs in the agency, obviously, just to make sure that we're all pulling, the same direction. And we oftentimes reach out to Leah and her team for help on that. And so we have in the past, when we've identified bad faith participation, have, sent warning letters. Now, just, we only regulate insurance companies, not the providers, but we also work pretty closely with the Medical Board and Health and Human Services Commission. And I don't know, Leah, if you had anything to add to that or.
Only to say nobody's been disciplined formally, and I would just say Cindy's team, they do a great job of reaching out to people when they identify problems and try to proactively do that. But it would be great for carriers to proactively reach out to the IDR team if they're struggling. There's been COVID staffing issues, there's been, inability to hire people staffing issues, and that can often cause things to snowball very quickly. I mean, those statistics you showed early on, I mean, it's a seriously intense slope about claims received, and TDI is working really hard to process those. I would love to never have an enforcement case for bad faith participation. That's my goal, and I think that's probably the industry's goal, and I think that's definitely the IDR team's goal. So communicate up front. If you have problems, communicate about it, and then nobody ever has to talk to me except Cindy, and that's great. And I think that's what everybody wants.
Thanks.
All right, sounds good. So there's your plan for the future. Next question, are there any plans to update the independent dispute resolutions to provide more data for reporting rather than just the full export?
Okay, so and I'll ask Randall for help on this one, because so if you're a portal user, so if you're a provider that has submitted requests through the portal, if you're a health plan or health plan employee and you work in that space, or if you're a mediator or arbitrator, those folks all have access to data that pertains to them within the portal, and they can download it. But we also have other data available that people can access. So Randall, do you want to talk about that a little?
I sure can.
Yeah.
And I think that one of the reasons Cindy's referring to me on this particular one, because I love to promote this information. The state of Texas has created what's called the Open Data Portal, where all state agencies, not just TDI, provides information that's readily available that usually would be available to the public through an open records request, is now available online on our website. It's the Open Data Portal. You can go there, and there's various components of data that we've added out there to include licensing information if you're looking for licensees. But more specifically to this question, we also have IDR data out there that's readily available. And it's pretty much all the information that's available to us is available to the public, is available on the Open Data Portal. All you would need to do to access that is to create an account. And once you create that account and you get your email confirmation, you now have access to all the information that's available to the public via that Open Data Portal. And you can download, copy, paste, do whatever you need to do to get access to that information to draw it out for your own use. But you don't have to submit an open record request for us to get that information. You don't even necessarily need to contact our IDR team to get that information. You can go out there directly on our website and pull it at your convenience.
Actually, excuse me, the specific web address is data.texas.gov, and you can get super nerdy with that. There's a lot of IDR data, there's complaint data, and TDI, like Randall said, is really excited to participate in that effort. It's new, and as time goes by, you'll see more and more state government agencies uploading information to it. So it's really exciting.
Yeah, and I suggest anyone to go out there and take a look. You'd be surprised the information you can get just at the touch of your fingers without necessarily have to put in a request to TDI and wait for that information to return to you.
Yeah, those are vast amounts of data, and it's really just as simple as adding a few filters, and it narrows it down quickly, and you get to the answers that you need. Next question. Are contracted providers eligible to file for mediation or arbitration?
No, actually. So if there's already a contract between the health plan and that particular provider, there should be already an understood rate for certain services. So that's specifically not eligible for IDR.
Yeah, and out of network facilities get the mediation. Out of network providers who are not facilities go to arbitration. So you don't get to pick or choose. It depends on the provider type, but basically facility or non-facility.
Yeah, can I just add real quick? If there are issues with a contracted provider and the carrier not paying the claims or delaying them or those types of things, then file a complaint with TDI and we will help you work through that. But it is not about the amount of payment that's there. It's about the process or the complete lack of payment, or maybe they're denying every claim. Consumer protection is there to help work through those with contractor providers, not the IDR process.
Yeah, thank you for adding that. I think that piece is really important. There are some things that, as we've gone along the last couple of years, we have come across situations like that where it's not a payment dispute, like you said, something else might be going on. And so, yeah, we're always wanting to, happy to research a complaint that anyone files about something else. Yeah.
Okay. Here's another one on fair health. Do parties have access to TDI's contract with fair health?
I'm not.
The question says one attached it as an exhibit to its brief. So that's something they've
Okay.
encountered.
I
Not
think
sure if it's on the website. It
Gotcha.
may or may not be available as a open records request. I suspect we've received that. I'm not sure the outcome of that, but that's, we are obviously responsive to Government Code 552, and there you go.
Okay, sounds good. Here's another question. It says, it can be difficult to coordinate mediation scheduling via email. Could there be a way as a mediator to offer dates and then have the health plan and facilities confirm those dates in the portal through the assignments, like a spreadsheet format?
So, one thing that we're always doing is we're constantly kind of evaluating, we're taking in feedback from, portal users and trying to, update, make enhancements to that portal whenever we can. We'd definitely be willing to take a look at it and see if that's something that we might be able to work in. I guess the underlying concern that I have based on the question is if the mediator is having difficulty getting the parties to come to the table, that's something that we would want to help with. So we would want to know about that kind of behavior because really, the mediator and our arbitrator, once that assignment comes to them, they're in charge of it. And, we obviously want to see the health plan and the providers respond timely and be cooperative, especially when, someone's submitting a request to begin with. Our assumption is, hey, you want to get that resolved. So we'll do everything we can in the program to, to help make that kind of thing happen. But yeah, if anyone's having a particular problem getting responses, again, that kind of goes to the potentially bad faith participation, and we would definitely want to look into that.
Yeah, and if I can, just to clarify, if you're having an issue, obviously, as Cindy indicated, communicate with us, let us see if we can help, but we're not your scheduler. So make an effort, see if you can get them to respond to you with that appointment. And only then, if you're having some issues, reach out to us, but we're not your schedulers. So we'll make sure that's clear.
All right, sounds good. This is another one about straddling that line between the federal and the state plan. If you have a claim that has components that would be covered under the state IDR process in part, but also the federal IDR process in some parts, can we submit the Texas DOS to the IDR process here, and then the other DOS to the federal, or do we just submit the whole thing to the NSA IDR?
Yeah, I guess I would have a follow-up question to it, which is, it like really where it goes should be pretty clear by the nature of the claim and what the health plan is. So I'm a little bit, we would definitely want to work with this person to kind of get a clearer answer for it. There are some things that the state law just doesn't apply to. Ambulance services is one of those, the federal law does, but the claim would be different for that than, for example, the emergency services where the person arrived at the hospital. So we'd be glad to answer the question in a little bit more detail, but yeah, I guess my only challenge is it should be pretty clear when the provider is presented with the situation, which process it should go. I can't envision a situation where you would have part of it going to the federal system and part of it coming through the Texas IDR.
Okay. We've got a fan that says the Texas process is a lot better than the federal process. So just shout out on that one.
Shout out to Texas.
We
Next
appreciate
question.
hearing that, and it's
Yeah.
certainly not the first time we've heard it. So thank you. Keep the feedback.
What happens if an arbitrator does not respond to one of their assignments?
Ooh, well, that shouldn't happen. If there's no, I mean, so let me just say this, each arbitrator and each mediator, handles their workload in the way that they handle it. So but what we have noticed is most folks seem to, right when that assignment comes over, up on their screen, they're responding back with a message to the party saying, hey, here's my introduction, here's my fee, here's the expectation. And if that's not happening right away, then definitely, we would want to hear about that. Other than that, I think what we would do is we would just work as quick as we can to resolve the issue. There have been some situations, we're all human. So there have been some situations, especially in these COVID times, where folks may have fallen ill, or maybe they had to travel out of country, or who knows. Things like that happen, and we've had to, maybe reassign or reset the clock on a request or two over the last 2 years. But it's a pretty rare occurrence. If someone's just not reaching out, we would want to know that right away.
Okay. A couple of questions about mediation versus arbitration. Are mediators' fees posted when providers and facilities are choosing who they're going to decide to work with?
Yes, so the fees, so the law required that Texas or that TDI post the arbitrator list on our website. So we maintain the arbitrators and mediators on our website along with their fees and links to each of their most current resumes or CVs.
Okay. Again, another question about arbitrators. Are arbitrators required to determine whether a case they've been assigned is actually eligible for arbitration?
So let me kind of walk a little bit through the process. When a provider submits a request, the questions that person is answering along the way. So the submission process itself kind of leads you down a path so that you can select yourself out if it doesn't meet the eligibility requirements of the law. So for example, one question would be, is it ERS, TRS, or, is it a fully insured plan? Then that's indicated by a TDI or DOI code on the front of the patient's or the enrollee's ID card. Excuse me. But after that, so let's just say I'm making my best effort, I'm submitting a request in here and I'm answering those questions. And in the end, I'm hitting the submit button. The health plan has the opportunity to review that request and let us know if there's something about it that's ineligible. So if the provider, in their best effort says, well, sure, this plan is eligible or covered under the law, the health plan might say, actually, that's a self-insured plan. And so it's not eligible for IDR. So there are a couple of, reasons like that the health plan might mark it ineligible. Then our staff at TDI kind of does a review of that. We're not making the decision about whether it's ineligible or not. Specifically, if we can't tell, if it's not super clear, we just have an obligation really to protect the consumer. So our kind of default answer is we're going to let that one pass on through the system. But anyway, hopefully that kind of sets it up so people can kind of understand the provider has questions at the beginning. Hopefully that takes care of it. If it's ineligible, they would know before they hit submit or wouldn't be able to hit submit. If they do, and there's some element of that that makes it not eligible, then the health plan has the ability to go in and say, and call attention to it so that we can review.
So it should be an outlier kind of situation.
Yeah. It seems like, so, I mean, gosh, we've got about 280 Randall, isn't it? About 289,000
9,000.
requests that are in the system right now. And so we're running about 10% of them tend to be ineligible for some reason. Most of the time it's because it happened to be a plan that wasn't eligible, like a self-funded plan.
Right. Okay.
I would say if you're an arbitrator and this is a situation, arbitrators are supposed to be looking at the data the parties provide and look at those 10 factors. The burden of calling balls and strikes about whether or not it is applicable or not applicable is not something that arbitrators should be struggling with.
Yes.
It's kind of not your job description. So if that pops up, let the IDR staff know and
Yeah.
we'll help you with it.
Thank you for bringing it back to the actual question. I was just giving the background, but yeah, that's something that by the time it gets to the arbitration shouldn't even be part of the discussion anymore. But yeah, so thank you, Bob.
So just raise your hand and let us know, send us an email. Here's another question. If we had a clean claim that was reimbursed low and mentioned NSA, but we missed the deadline to start a negotiation with IDR, are we still able to appeal to the insurance company for a higher reimbursement?
I mean, so we're not an insurance company. I can't think of anything that would prevent someone from trying to negotiate or reach out to a company, appeal, or have an offline conversation, to try to settle a dispute like that. IDR isn't mandatory. And so, we always encourage providers and health plans, if they can, get in the network, great. If not, then IDR doesn't have to be the first choice for anyone to try to resolve their dispute. But if you engage it, then that's really where most of this conversation comes from. So.
All right, next question. Is there a way to share access to a particular mediation request on the IDR portal with other users in your business, or can only one person have access to the mediation information at a time?
Yeah, so each login has access to their own information. So that's pretty much, it's one user.
That's the way
one
it's set
login.
up.
Yeah.
Here's a question. A party referred me to Texas Health website that seemed to be something that the TDI compiled and requested that I use that instead of Fair Health because it was limited to Texas. That may be the price compare for procedures.
Yeah.
Is that really data compiled by TDI that we can use or we should use?
Well, I guess I would say it probably depends on who you are. I think that website was established to really help consumers and provide them just some general information when they're kind of shopping around for different services. But if you're an arbitrator, no, Fair Health is the only benchmarking database that they should be using.
Okay. Next question. Are you able to filter data for specific plans IDR disputes on the open data portal?
No,
No,
I don't believe you can filter. So, and I'm going to reach out to Bob for this one too, because, excuse me, we present aggregated information. It's not identifiable by health plan or provider. And, that was written into the bill. So, yeah, so we do get a lot of open record requests every now and then. And that's why, frankly, why we wanted to put as much information as we possibly could on the open data portal so people could kind of dig around in it and see what's going on. But it's not identifiable. That's not something that we can do at all. So we're not going to provide information that's going to, describe any program data with relation to an individual company or provider or arbitrator or mediator.
Okay. All right, next question. This is one that's about a specific issue. He says, we are an out-of-network pathology group that serves an in-network hospital. Can we bill the patients? Can we balance bill, or do we need to go to this mediation?
So that is going to depend. It is probably a fairly complicated answer. If it depends on what the health plan involved is and whether or not that there are, I think, 5 parallel provisions in the insurance code that apply to non-network diagnostic imaging providers, and they tend to specifically prohibit balanced billing. So if that's the scenario, then balanced billing would be prohibited. However, there is an exception, and out-of-network providers can get a waiver. There is a form, I think it's on our website. I think it's shared. I think it's also maybe posted by the Texas Medical Board website. And so there are resources out there. So there is a procedure and there are rules on how to get a waiver, because the statute fully contemplates that there may be consumers who want to opt to an out-of-network provider for their own personal choices, and then that could lead to balanced billing, as long as basically they have proper disclosures and notices. So it is possible. You just have to kind of go through the steps.
Okay.
And then I guess it says mediation. So presumably these are out-of-network non-facility providers, so not mediation, rather arbitration. That said, and I think kind of Cindy brought this up, I mean, we encourage providers and facilities to, settle informally outside the IDR process. So there's nothing preventing people from voluntarily entering into a mediation to resolve disputes. Please, by all means, right, resolve things by outside of the process. And if a provider would like to work with health plans to have a mediation, and great. Voluntary settlement is a-okay.
All right, sounds good. Here's a question. Is an attorney able to submit an IDR request on behalf of a provider or facility and serve as the contact person through this process? Can somebody else?
Sure. Well, the answer to that really is just as long as you have an agreement, everybody agrees that you're representing that practice. There's, that TDI doesn't have a problem with that at all. We would actually, when you're walking through a submission, one of the questions is the first question is, I'm representing a provider or facility, or I am a provider facility. And so we try to ask that right out of the gate. And then by the end, there's another sort of affirmation that, yes, there's an understanding here that I'm representing this practice. And then the things to bear in mind are, and we've had an issue with this really more early on in the program, more so than I don't think in the last more than a year we've dealt with it. But we have had situations early on where there might be a billing service or some representative that's wanting to, submit requests through our portal, but maybe not fully understanding that not only are they submitting the request, but they're also, responsible for participating, including if the negotiation doesn't settle the dispute in the informal period. If it's assigned to a mediator or arbitrator, the mediator or arbitrator has to be paid upon assignment. And so I think that's part of where early on we had a little bit of, trouble with folks that were looking to maybe represent a practice or a facility, that some may not have gone into it with that full understanding that, someone is on the hook here for a payment if that case assigns. And so, that's just something we always want to let people know.
Okay, here's another one for the legal side. During the last session, it was stated that 1264 mediation is a voluntary process as it relates to providers and payer reimbursement disputes. Where the 1264 mediation process is invoked, though, a party is prohibited from initiating litigation until there's an impasse or a mediation process is completed. However, if the voluntary mediation is not invoked by either party, can it go straight to litigation at that point?
I'll reach out to Bob for help on this one. So, if they engage in the mediation, that's sort of the, if you're ultimately going to litigate, then you've got to try the mediation first, basically.
Yeah, I'm not even really sure that's a question, but I think
Yeah.
that's, yeah. You can pull up insurance code 1467, that subchapter, and see for yourself. But yeah, and it is well taken that there's a distinction between the arbitration and mediation processes, and that's one of the kind of distinctions that exists. But yeah, mediation is voluntary, sort of, it's a mandatory voluntary process. Say that.
All right, next question here. How would a mediator get their fee amount updated, changed with TDI? Do we email for that?
Yeah, I mean, that's pretty easy. So our team, our IDR team is small, but they're always glad to help. And so, and this is something that's kind of happens relatively regularly, that we have an individual that'll want to, update for whatever reason. There's new information to put on there, or maybe they need to update their fee, whatever that might be. Just email us at IDR and we'll let it
At
take care of it.
tdi.texas.gov.
There you go.
Here's a question just for clarity. Are self-funded insurance plans eligible for the ID process for both federal or state, or just state? Where does a self-funded plan go?
Self-funded go to the federal process. Fully insured, provided it falls within the applicability of statute, will go to the state process. I'll let Cindy talk about the process and how that.
Yeah, well, so ideally, this is information that you would gather up front, that you would be able to know by looking at the patient's health insurance ID card. It's a pretty easy indicator of whether or not it's fully insured. And so if it is, it's going to have a code on the front of that card, and it's going to say either DOI or TDI on the front of the card. And that's a pretty easy indicator. And then, we always say, fully insured or self-funded, but, the law covers Teachers Retirement System of Texas and Employment Retirement System of Texas, those plans.
Okay, sounds good. We had a couple of questions asking about the slides that you presented earlier. There will be a recording of this session, and you'll be able to rewind that and see the beginning of that at your leisure. Here's a question. Is there a website where providers can see the QPA for various insurance payers?
I'm not really,
Not ours.
I'm not really sure. I don't know, Leah, if you would know. Health plans may present that information on their own websites. TDI doesn't maintain examples like that. We do have, and they're not real examples, but we have some, mock-ups of where to find that code on the front of the card, for example, in that regard. But I don't think that I don't know where to find examples of the specific examples of the QPA. Unless they're on each individual insurance company's site.
Okay, yeah, we don't have that one. Here's a straightforward question, I think. What happens if we can't get a copy of the insurance card?
Yeah, so if you can't get a copy of the insurance card, then our suggestion is typically, reach out to the health plan, excuse me, just to confirm whether or not, it's a fully insured plan.
All right, sounds good. I think we're going to wrap it up there because we've got 1.5 minutes left. So once again, we're out of time. We've taken an hour of questions plus the ones we did last time. So if we didn't get to your question today, or you think of something else that you need addressed, please send it to the email idr@tdi.texas.gov, and we'll try to get you an answer. And if you want to review this session or any of the 2022 virtual compliance conference sessions, you'll find them on our homepage of the TDI website. Just look under news and updates and click there, and it'll have all the recordings and all the slides that were used in those presentations. All right, it's 3 o'clock. That's it for today. Thanks for joining us. Have a great rest of your day, and we'll see you next time.